We stand in your honor. You can see as you enter. Ladies, you're always welcome to leave your purses back there. There's a little cubby holes. That room will be secured. So if you don't want to bring that in and out with you, you can leave all your personal belongings in any one of those cubby. Okay. Please be seated. Right, this is cause number CR 21-00076, State of Texas versus Charles Justin Howard. Good morning, ladies and gentlemen of the jury, and welcome back. We give you some information about how we're going to proceed today. Just a moment, the state is going to present their indictment to Mr. Howard. He will then enter a plea before you, after which time both the state and the defense will be permitted a chance to make opening statements to you. After opening statements, the state of Texas, bearing the burden of this case, will have the opportunity to call its witnesses first. The state will question their witnesses. Once they have passed the witness for cross-examination, then the defense will have an opportunity to question the witness. That procedure will go back and forth until they're both confident that they received all of the evidence from that witness, all of the testimony from that witness, at which time the witness will be excused. We'll go in a like manner until the state has called all of its witnesses, produced all of its evidence, at which time the state will then rest before you, meaning that they have admitted all of the evidence they intend to admit in the case. At that time, then the defense, if they would like to, are allowed to also put on a defense. But as you will understand later, and you know already, the presumption of innocence alone means that the defense does not have to put on any type of defense at all. So they're going to be permitted to do that if they so choose. All right. After the state rests and the defense rests, then we will move towards closing arguments, and you will receive the court's jury instructions prior to closing arguments. Once you receive the arguments, then you will be discharged to deliberate the case and return. Okay. All right, Mr. Hartwell, on behalf of the state, are you making opening statements today?
Yes, sir.
May proceed.
Thank you.
Oh, I'm sorry.
Would you like
Yes, let's go ahead, and Mr. Howard, please rise. And Mr. Hartwell, if you will present the indictment and cause number CR 21-00076.
Yes, sir. In the name and by the authority of the state of Texas, the grand jury for the county of Van Zandt, state of Texas, duly selected, impaneled, sworn, charged, and organized as such at the January term AD 2021 of the 294th Judicial District Court for said county, upon their oaths, present in and to said court at said term that Charles Justin Howard, hereinafter styled defendant, on or about September 14, 2020, and before the presentment of this indictment in the county and state aforesaid, did then and there intentionally and knowingly possess a controlled substance, namely heroin, in an amount of less than 1 gram, against the peace and dignity of the state, signed foreman of the grand jury.
Thank you, Mr. Hartwell. Mr. Howard, how do you plead to that indictment? Thank you, sir. You may have a seat.
And Your Honor, state would like to invoke the rule.
All right, do we have any witnesses? All right, if you'll go ahead and bring them in. State, do you have any witnesses that?
Yes, sir. At this point, I'm not out standing for which damage.
Yes, I have any witness that's here that intends to testify to be placed on the roll needs to be present. Gentlemen, have a seat. It'll be just. Will all witnesses come forward here before the court? All right, witnesses, the rule has been invoked. You are ordered to leave the courtroom and not re-enter unless instructed to do so by the bailiff. Or you're not to discuss the case or your testimony with other witnesses or anyone else except the attorneys. You're not to read any report of or comment on the testimony or evidence in this case. Any witness violating this instruction is subject to being held in contempt of court. Do all of you understand? All right, so you'll return to the hallway or room. You don't have to stay in this hallway. You can move about the courthouse. Just be within earshot of the bailiff so that when he calls your name, you'll come in at that time. Okay. Mr. Hartwell, are you ready for your opening statement?
Yes, sir.
You may proceed.
Thank you. Yeah, Mr. Court. Good morning, guys. I want to start by thanking you all for coming back. Might seem a little bit weird to thank y'all for returning this morning, but believe it or not, we've had situations where a juror doesn't show back up the next morning and causes quite a delay and cause a mistrial. So truly, I do thank you. I appreciate your time. We're going to try to be as respectful as time as possible. We're going to try and be as efficient as possible. I want to start by explaining a little bit about what opening statements are. Each trial is kind of like putting together a puzzle. You have different pieces, and it becomes more clear as the trial goes on. So what opening statements does is gives us the chance to give you kind of a framework, kind of a preview, so that when the evidence starts coming in, you can start putting that puzzle together. So this gives us a chance to tell you what we expect the evidence is going to show. So what I expect the evidence is going to show is that on or about September 14th, Officer Barajas with Grand Sleeve meeting was patrolling and spotted a vehicle with a broken tail, specifically the license plate light. That he made a stop on that vehicle based off of the defective license plate lamp and made contact with the defendant, Mr. Howe. I expect that at some point, Officer Barajas got consent to search the vehicle, and that upon searching the vehicle, heroin was found. I expect that you're going to see that there were other people inside the vehicle as well, and that Mr. Howard was driving. I believe you're going to see that there's a front passenger and a rear passenger. I believe that you're going to see that along with the heroin that was found, Officer Barajas also found some unused needles that he also found some scales, some baggies. I believe you'll find that he found a quantity of cash and along with just some other paraphernalia type items. So the things that I'd like you to pay attention to in this trial, really, there are a few elements that we have to prove. We have to prove that on or about September 14th, 2020, in Van Zandt County, the defendant intentionally or knowingly possessed it. That's basically what we have to prove to you. And I have to prove every single one of those points in order to have proven my case. If I fail on even one of those, then you must acquit at the end of this trial. But what I really think we're going to come down to, what I expect the point of contention in this trial really is going to be about, is whether Mr. Howard intentionally or knowingly possessed heroin. So when you're listening to evidence, what I want you to pay attention to is the evidence that shows that those points. Of course, pay attention to the others. Again, if I fail even a single one of them, then your verdict must be to acquit. But again, I don't think many of these elements are going to be at stake here. I believe the only one in contention really is going to be the knowing intention.
Thank you, Mr. Hartwell. Mr. Schmidt, would you like an opening statement?
Yes, sir. Thank you.
Morning, ladies and gentlemen. Good to have you. This case is going to be fairly simplistic. As you heard, we discussed a lot about definitions of possession. Knowing what intentionally possessed. I believe that the states can present evidence, and we can present evidence that shows that September 14th, 2020, Officer Christian Reyes did a traffic stop for a traffic violation that was driven by Mr. Howard. Inside the vehicle, 3 individuals, Charles Howard, Brittany Hamilton was in the passenger seat, and Mallory Gaw was in the back seat. Within minutes of the stop, the officer requested to search the vehicle. And Mr. Howard exceeded and said that it was searched. Ms. Gaw was left in the back seat. Ms. Hamilton and Mr. Howard pulled out of the vehicle. Within minutes to the stop, you can see that the officer communicated with Ms. Gaw while she was in the back seat. After the search began, Ms. Gaw out of the back seat and found what some would consider drug paraphernalia in the back seat. So Ms. Gaw was questioned about the syringes. One was used. She was confronted with a used syringe in blood. She claimed it was hers. The officers looked at the syringe and determined that there was a crystal substance inside the syringe. It did not test that syringe. They continued their search with Mr. Howard in custody. They ultimately placed Ms. Hamilton in custody for other charges and continued the search. After he searched for quite some time, the officer found what he believed to be methamphetamine in its syringe in the center console. All 3 of the individuals denied that it was theirs. Ms. Hamilton had already been arrested at this point for tampering with physical evidence on scene, possession of penalty group 3 pills. So she was in custody on the side of the road. Mr. Howard was in the vehicle and at all times denied the heroin that's in the vehicle that possessed it. Ultimately, you will notice, curiously, Ms. Scott was not arrested. She was released and let go. The other 2 individuals were arrested. Mr. Howard is the only one in the vehicle that didn't have any substances on his person. He consented to the search of the vehicle. Ultimately, Scott in the back seat had what initially, at least the officers believed to be contraband drug paraphernalia. Ms. Hamilton had controlled substances on her person and was arrested for that. And ultimately, the officers received and states evidence that they had a discussion on the side of the road about what possession and who possessed it and who could be arrested, because they didn't know it. So ultimately, they arrested Mr. Howard and Ms. Hamilton. Did not arrest Ms. Scott. They got her. It did not test materials that were in the springs that she. So at no point in time did Mr. Howard possess, seeking the evidence that not only did he not possess it, but he disclaimed knowing it was there, disclaimed ownership, disclaimed use. But Ms. Gaw in the backseat, who had been able to do to Ace Ranch in the vehicle, for some reason, officers took her loose. I won't get into that. But ultimately, I think the evidence will show you that there were 3 people in the car. 2 out of the 3 were arrested. 1 of them maintained, didn't know it was there, didn't possess it. Yeah, so I think they can see that it's not to come to the program that the officers could even by their own discussions.
Thank you, Mr. Schmidt. Deputy Ortiz, let me remove the podium. Remove the podium. Farwell, is the state ready to call his first witness?
Yes, Your Honor. State calls Officer Barajas, Cranston.
Sir. All right, ladies and gentlemen, the jury, have an unforeseen issue, and so I'm gonna ask that, you gather into the jury room, remain there until I notify you again throughout the course of the trial. This is not atypical. Oftentimes issues come from the court must rule on or discuss outside of your presence, so the court's gonna do that. I'm gonna ask that you remain in the jury room if for at least 10 minutes. If our break's gonna go longer than that, if Martinez will knock on the door, they'll notify you, and then y'all will be able to disperse throughout the building, go outside, do those things, okay? So I'll be with you in just a moment. All rise for the jury. All right, we're gonna stand in recess for 10 minutes. All right, you may be seated. All right, ladies and gentlemen, I apologize for that brief disruption. At this time, I believe the state has the motion. Is that correct, Ms. Gray?
That's correct, Your Honor. Last night, Your Honor, defense counsel pointed something out to me on the video of the traffic stop in this particular case that needed to be further researched. I researched that this morning, Your Honor. I visited with the officers from the Grand Saline Police Department this morning. And it came to my attention that there was additional information concerning this case that was not submitted to the district attorney's office when this case was originally submitted or any time since then and before today. As the court knows, Texas Code of Criminal Procedure, Section 3914 requires that all information concerning a case be submitted to the district attorney's office, and that all information in the possession of the district attorney's office, save and except attorney work product, be turned over to the defense attorney. If that obligation is not met, it puts the assistant DA handling the case at risk of losing his law license, and it puts the district attorney who supervises him or her at risk of losing their law license, or at least being disciplined on their law license. Judge, that is not a risk we are willing to undertake. It is unfortunate that we did not receive all of the information from the Grand Saline Police Department so that we could make that available to defense counsel. If we had received it, we certainly would have made it available to defense counsel. The most unfortunate part is that it is not information that I believed would have affected the case one way or the other. It's not information that indicates any officer did anything wrong. But the law requires that all information be submitted to me so that I can turn it over to defense counsel. In this particular case, Your Honor, that was not done. The only ethical thing for me to do at this time is to move to dismiss this case.
Mr. Schmidt, any response?
No response.
All right. Then, considering the merits of the motion, the court will grant the state's oral motion to dismiss this case. That is granted. Mr. Howard, as the defendant in this case, you were indicted by the Van Zandt County Grand Jury. You were held open for trial. The state has dismissed your case, has moved to dismiss your case. That's been granted by the court. You're free to go. Ladies and gentlemen, jury, obviously your duty is now discharged. So any previous instructions I've given you about not discussing the case, what information you have about it, you're no longer required to honor that. Free to speak with anyone that you so wish, and likewise free to not speak with anyone. All right. So what I'm going to do before I fully discharge you is I want to speak to you in the jury room again to thank you for your service, get some feedback from you, and then counsel for the state, counsel for the defendant, Mr. Schmidt. They may want to talk to you afterwards to get any feedback that you have for them. Your service has been very brief. So typically when they meet with you, it's to get information that helps them in their practice regarding their presentation or your insights on the case. That might not be the same in this case, but you may have questions. And if you want to stay, I'm sure that they'd be very welcoming on trying to answer your question. So this time I'm going to ask that everyone rise for the jury. Jury, if you will gather in the jury room, I'll be there in just a moment.